feel like I've been properly set up for this right now, talking about Z clauses. You'll have seen lots of references to Z clauses through the sessions this morning. We can't escape them. I am a lawyer, and I have to confess that I do love a good Z clause. With the emphasis on good, though, and we will talk more about that. Obviously, we know that NEC says they should be kept to a minimum, and time again, we do see that we're getting pages and pages of Z clauses, or as Matthew said this morning, there's much more in the red line. There's much more red than there is black. And, is it a good thing? Are these NEC contracts being built on and improved by reams of Z clauses for greater clarity? Or are all Z clauses at best unnecessary and at worst contradictory and creating unintentional changes to the balance of the risk allocation? And is it a case of the curse of the Z clause? So, obviously, we as lawyers, we look at a wide range of Z clauses. We help clients draft Z clauses, and we also review them for contractors, advise on pre-drafted clauses, and we often unpick a lot of the issues that I'm going to talk to you about today. So we're going to start with a bit of an introduction to Z clauses, in case anyone was under any mistake as to what they are. We'll look at the pros and cons, a number of common issues in drafting them, a few tips on how to draft them, and then we'll look at examples and the issues that arise with what are commonly included Z clause. And now, Glenn sent a survey to you previously, which many of you have helpfully filled out. And so I will be referring to some of those commonly included Z clauses that you guys have all seen. So, Z clauses, what are they? They are referred to in the NEC as additional conditions of contract. There's actually quite a small box for them to be inserted in contract data at end of part one. And incidentally, I've never seen that used to actually list out the Z clauses. I've usually seen a reference to the separate document that has the pages and pages of Z clauses. And I'm sure that's the case for many of you. And those Z clauses do include additional conditions, but they also amend existing conditions. So again, all the things I've mentioned there is perhaps not quite in line with what NEC was intending. And NEC, as we remember, was developed by experienced practitioners, the intention being to fairly apportion risk between the parties, and the very nature of the contracts have that inbuilt flexibility, the sort of pick and mix ability to choose your secondary options, your main payment options as well, with the intention to do that for a particular procurement route, where other standard form contracts would actually require a lot more amendment. So the NEC is clear that it doesn't need any detailed amendments, they're not appropriate, and also that a lot of Z clauses should probably actually go in the scope, particularly if they are detailing a process of how the contractor is to carry out the works. So just looking at what NEC says there, it says additional conditions should be used only when absolutely necessary, which I've underlined there for emphasis, just to be clear. And it's to accommodate the special needs such as those specific to the jurisdiction in which the work is to be done. Additional conditions should never be used to limit how the contractor is to do the work in the contract, as this is part of the function of the scope. So why do we still see lots of the pages of Z clauses, and is it always wrong? Clearly not. The NEC is anticipating by their very existence that they must be needed in some certain circumstances. So when should we be thinking about a Z clause? So obviously, as a lawyer, I've put the lawyer's point of view in the first instance, which Barry and I have just had a good discussion about. So the language is largely untested by the courts from our perspective, so interpretation can be a bit open on many of the clauses. It's not as well tested as some other standard forms in the courts. It is tested, though, and I'm sure many of you have found that it has been tested. It is tested in adjudications, which don't reach the courts, and we don't all know what the outcomes of all of those adjudications are. And quite often you'll find lawyers or other practitioners who what they're actually doing is putting into the contract, into those Z clauses, their experiences of where there's been perhaps an ambiguity that needs to be fixed. You may not even agree with that ambiguity, but if there is an ambiguity, when you're going into another project, you probably want to fix that so it doesn't happen again. and make sure that it's not interpreted in an unintended way. Now, there are often a number of clauses that are included from clients, and this, again, I know will be very much open to debate as to whether or not that's correct. There may be some that are specifically needed. You might be looking at the payment procedures. The client may need an invoice at a certain time, which isn't necessarily covered already by the NEC. You might also find that there are things like the sort of more boilerplate clauses, the anti-bribery, modern slavery or sanctions wording, which must go into perhaps the client or even the contractor's contracts to get through their governance processes. And we'll also see lots of project-specific amendments. So things like sometimes you see a design development process, again, that could arguably be in the scope. But also, you see references perhaps to other agreements or other influences on that project, if particularly in a large project. You may even see, if you're in a subcontract, you may see a reference to flow downs from the main contract. Z clauses in practice. Well, NEC has even approved some Z clauses. So we did previously have the public sector Z clauses, which were published by NEC, and it covered things like the Official Secrets Act, confidentiality obligations, site security. Crown Commercial Services also have published their NEC boilerplate clauses, which this includes things like admittance to site, anti-bribery, corruption, freedom of information, BIM, GDPR, all things that you're probably quite used to seeing going in as Z clauses. And these amendments were taken from a wide selection of government contracts looking at commonly used Z clauses across a number of their projects, and Crown Commercial Services also consulted with the Infrastructure and Projects Authority to achieve what they considered a fair balance in the risk allocation. So even NEC might concede here that further Z clauses might actually be needed for clarity. So what are the common issues that we have with Z clauses? And it's been mentioned many, many times. I've already mentioned it myself. There can be far too many of them. And they're not necessarily tailored to the project or the parties. It can be perhaps a copy and paste of those standard Z clauses that we've been talking about, without any thought going into whether they're actually appropriate for this contract. And one risk of that is that having too many amendments in there, if there are actually some key amendments to that project, it gets a bit lost in the sort of sea of Z clauses. And the contract becomes so unwieldy, it becomes difficult for the parties to comply with all of those provisions. They're not necessarily even aware of them. You're putting people off of reading the contract, essentially. And if they try to comply, then it could be unnecessarily and costly in terms of the administrative burden that it creates. So another thing that we see regularly is that the language is often also inconsistent with that of the NEC. So again, we're talking here about the bad Z clauses. Things I often see are introducing capitalised terms for terms that are actually identified in the contract data, but those italicized terms aren't deleted. You see a mixture of the two. And if they're defined differently, it gets confusing and, again, can have unintended consequences. There's also a risk of adding clauses without considering the crucial interrelationship between the existing core clauses and secondary option clauses that have been selected. And it can lead to repetition and conflict or inconsistency, even if there's only a slight difference in the clauses, sometimes particularly if there's a slight difference between those clauses. And we do also see sometimes Z clauses which deal with matters that are actually already dealt with in the contract data or in the scope. So again, it's a case of just sort of really being aware of what is already there and what are you replicating. Sorry. So again, another issue that we see is where there's a particularly adversarial clause or there's substantial changes to the risk allocation. Such clauses are likely to be inappropriate if they depart too much from the NEC ethos, and perhaps a different contract with that appropriate risk allocation might have actually been better suited to that project. And actually, that sort of reminds me of, is one of the first pieces of work I did, I think, on NEC. It was soon after the release of NEC 3, and a client had asked us to take their standard JCT amendments and convert them to NEC Z clauses. We did point out that was essentially trying to fit a square peg into a round hole, as it wasn't just a matter of changing the language and changing the sort of cross-references and clause references. It actually may, there was actually a different risk allocation that had to be taken into account. So our task was clarified. So instead we were to amend the NEC risk allocation so it was the same as the JCT. Obviously begs the question, if the JCT risk allocation was preferred and to be replicated, perhaps better use the JCT.
It's never better.
Again, arguable, but and if those people are happy to pay lawyers to do that, then so be it on them. Whilst none of those clients are here today, just to clarify. And whilst the preference may be, and particularly at tender stage, to push a lot of the risk onto one side, and particularly perhaps onto the contractor, that this can, we talked about it just before we had the break for coffee. It goes against, it has adverse effects on the contractual processes. It goes against the ethos of the NEC and the spirit of mutual trust and cooperation. And essentially, as Glenn was saying, the contractor is going to price for it. If you're in a target price contract, that risk is going to be shared. It goes somewhere. That risk doesn't just sit or disappear just because you delete something from the contract. And again, the issue with that, obviously pushing that all onto your contractor, can they pass that down to their subcontractors or specialist contractors? You'll be hearing about that later. Can they pass that down? Is there going to be some sort of gap? Is there insurance? There's all these things to think about when really playing around with that risk allocation. So where do we start when we're drafting Z clauses? What do we think about? So, and this is generally kind of slightly borrowed from NEC guidance, actually. Which I'll talk about in a minute. But the first thing to think about is, why is the clause needed? Is it dealt with already? Should it actually even be a Z clause, or should it be the scope? As lawyers, we're often reluctant to leave important conditions in the scope because we don't draft it. And obviously, we want to make sure that if it's that vital, that it is actually in the conditions. But it is important that someone is familiar with the conditions and any amendments as well to the scope to ensure that there isn't a conflict. And we'll talk a bit more about that later. What's needed? What's the interrelationship with the core clauses? I talked about that just now. Is there a conflict? Is there something dealing with it already? And it's not just, is there a conflict with a clause that's directly there? Because NEC doesn't do the more traditional contractual cross-referencing. There will be other clauses that are impacted, and it won't be referenced in that one clause. 60.112 won't tell you all of those other things. You've got to look for it. So really, it needs someone that's quite familiar with the contract. Now, the third one there, maintaining the NEC key principles. A reminder of those, flexibility, clarity, and stimulus to good management. Is the amendment clear? Will it assist management of the contract? And obviously consider the language and the style and make sure all of that is consistent. And then moving on now to don't just copy and paste. Don't take a set of Z clauses and go, this will be applicable. Because, as we said, that's how you get lots and lots of Z clauses, because they're not all appropriate. And that creates problems. You've got things there that aren't necessarily appropriate, that perhaps need to be applied. They don't make sense on that project. So beware of doing that. And I think one thing that I disagree with, and perhaps it was unintended in the NEC guidance notes on this point, and it relates to the sort of copy and paste approach and the sort of flexibility. I don't think there is actually that much room in Z clauses for flexibility. I think the point of a Z clause is to clarify and tailor the contract to that specific contract, to that specific project. The NEC says in the guidance notes when it's talking about issues to consider, talking about maintaining flexibility so it can be applicable in any jurisdiction and for any project. We're not talking, when we were talking about Z clauses, we're not talking about any project. Obviously, if you've got standard ones, perhaps you are. But I think generally the feeling is, do we really want standard? Is there a standard Z clause that should be applied to everything? Perhaps not. So I'm just going to go through now some of the common examples of Z clauses. You may, I'm sure, disagree with me on my opinion on many of these, but I'm just giving you sort of on each of these, the issue can be drafted either way. It can be drafted well, it can be drafted badly, it can be drafted for clarity, it can be drafted as a curse. And I'll try and cover those in a sort of fairly balanced way. But I think these Z clauses here are perhaps ones that are needed more for clarity. Boilerplate clauses, I've just put that up there. There are some that aren't in NEC, so you've got things like severability, no waiver, survival after termination, things like that. Things that were in those Crown Commercial Services boilerplate clauses, not all of them, don't take them all and just dump them in. But there will be boilerplate clauses that are included in contracts time and time again, and there's a reason for them. There's case law, and you may not think that they are particularly appropriate or necessary at the time, but if you get into a dispute, you may regret not having them. So actually, now the next few actually, these are actually examples, I think, of where Z clauses have traditionally been used, particularly on NEC 3, and with NEC 4 coming into play, they were actually inserted into the contract, but we're still seeing the Z clauses being used instead of them. And I think, again, this is generally because the parties consider that the NEC 4 has not dealt with the issues sufficiently. They prefer their old drafting. But it is an example of where parties have to be even more careful to consider including them, because there may actually already be now an existing clause in the contract that deals with it. And one of those examples is clause 28, assignment. So there's now an ability to assign. The parties can assign. There's also a requirement for the client not to assign if the party to whom it's being assigned to does not intend to act in the spirit of mutual trust and cooperation. Now, that one might be a little bit of a difficult one to prove, I think. I think that one is quite often amended. And often the sort of more standard in the market amendments will go in, so further restrictions included on perhaps the type of party to whom a contract can be assigned, or a restriction on the number of assignments, or perhaps just saying there can be no assignment without the consent of the other party. And you might also want to include, going further, a requirement to novate perhaps to a group company of the party or similar. Again, looking at clause 29, there's a very simple confidentiality clause included in NEC 4. But again, parties often include their much more detailed provisions relating to confidentiality to further clarify the exceptions of when it might be necessary to disclose. And this may be because they have particularly sensitive confidential information that they're trying to protect. But again, if this clause can be amended, or if the standalone Z clause is to be used, then in that case, 29.1 should be deleted. So just remember, you've got two clauses there otherwise. If you stick a Z clause in, remember to do something with 29.1. Now, if you look through the contract, even NEC 4, for a clause dealing with collateral warranties, you may be mistaken for thinking that it's entirely missing. But on a second glance, X8 appears to address it, and where it refers to undertakings to the client or others. So, although it does seem to cover the same circumstances in which a collateral warranty would be given, it's not surprising that parties still prefer not to select X8 and insert there probably NEC 3 carryover Z clause, which specifically refers to collateral warranties or third-party rights, calling a spade, essentially. And similarly, the simplistic transfer of rights provision at X9 is often not used, and you see the more detailed intellectual property rights provisions inserted. Again, there may be particular intellectual property rights concerns on many particularly complicated projects, licenses and license restrictions that need to go in. And again, just a reminder, you've got to remember everything that's in the whole contract. X15 also deals to some degree with this as well, and generally looking at all of the design obligations, all of those things should be considered when including it, when looking at this, to make sure that you're not actually having contradictory provisions. Again, depending on the type of project, then you may want to include a Z clause to amend the insurance provisions beyond what's included at clauses 83 to 88. And this may be to supplement the core clauses for particular project-specific policies. A slightly more controversial provision, I know this is more one for the lawyers and many of you may disagree, is one not included in NEC 4. It's the obligation for the contractor to proceed regularly and diligently. Again, may depend on whether you're the client or the contractor on this one, but I think generally if you're flowing that down to your subcontractors as well, you may actually still want that kind of obligation to flow down. So I know the view often is that this is quite a subjective term, and I know that this year I'm not meant to be doing the case law update, but I couldn't resist a little case in there anyway. So just looking at how the courts have interpreted an absence of the obligation to proceed regularly and diligently. In that case, Leander Construction and Mullally, Leander was engaged under a subcontract to carry out works for the contractor Mullally. Mullally issued a withholding notice on the basis that Leander had failed to carry out the subcontract works in accordance with the programme dates and periods that were included in the activity schedule. Now, it was accepted the dates in the activity schedule were not contractually binding. However, Mullally argued that Leander had an implied obligation to proceed regularly and diligently with the works. And the activity schedule was mentioned because it represented the best way to measure whether or not Leander had complied with that implied obligation. But the judge refused to imply a term into the subcontract to oblige the subcontractor to proceed with its works regularly and diligently. And they did also say that I gave some insight into what that would mean, what regularly and diligently would mean. Because logically, it means it's dependent on the time period within which the obligation needs to be carried out. So essentially, if the contractor is obliged to achieve a certain outcome in 12 weeks, it may be necessary for the contractor to exercise more haste than if the obligation is complete within 24 weeks. So if you've got a contract and you've got lots of binding key dates and lots of short lead times and sectional completion dates, it might not be too much of an issue. But if you have got long lead times on particular activities in the contract, it might be a useful tool to include in the contract rather than waiting until the contractual end date until that is missed to have any recourse under the contract. Again, good for the client, not as good for the contractor, but also think about the subcontracts. It's not necessary, an obligation to proceed regularly and diligently isn't necessarily departing from the ethos of the NEC, at which point many of you are probably thinking, well, couldn't we just rely on the spirit of mutual trust and cooperation? And my answer to that would be a very heavily caveated perhaps. Sorry, very lawyer's answer there. It's by no means clear or certain. So I think in the interests of clarity, my preference would always be to put that in. So now looking at something that I know from the survey was something that many of you encounter. I think it was mentioned briefly in one of the sessions earlier. So the order of priority clause, which is something that many of you have come across, and essentially it will be used in the event of a conflict between conditions and scope, perhaps, or to establish that the conditions take precedence or vice versa. There might be multiple documents forming the scope. These might be listed in order of priority as well, and we sometimes even see provisions saying that the Z clauses take priority over the core conditions. NEC purists will state that this is not needed because the contract should simply be read as a whole together. But the practicalities of putting together a contract, particularly on larger projects with heavy negotiations and tight timeframes, it can be difficult to ensure that there aren't contradictory items, particularly since the contract and the scope are usually prepared by different people. So in the case of RWE and MPOW, it was an order of priority clause that you will all be very familiar with. So the clause stated, this was an NEC 3 ECC contract, by the way. The clause stated that the NEC conditions and amendments had priority, contract data parts 1 and 2 were next, post and the clarifications, then works information, then site information. There's no surprises there. Now on this contract, there was a delay in completing the pipeline, but an adjudicator held that section 2 of the works, as defined under X5, had been completed on time on the basis that there was an inconsistency between X5 and 6.2 of the works information, and X5 therefore took precedence. X5 was defined in more generic terms, requiring completion of the pipeline to the extent necessary for it was a hydro plant to be installed, and only a short length of the pipeline was needed for that purpose. But 6.2 was much more detailed and required that the pipeline would be fully installed, completed and tested. Taking it to the courts, the judge held that the agreement should be read as a whole and construed so far as possible to avoid inconsistencies on the assumption that the parties had intended to express their intentions in a consistent and coherent way. So X5 and paragraph 6.2 could be read together. X5 was worded in more general terms, 6.2 provided greater detail, and both purported to define the content of section 2. However, the court held that one would expect the two to complement each other. The order of precedence would only be necessary to refer to where different provisions on their true construction impose different obligations in relation to the same subject matter. So just a warning there that you may have your order of priority clause, but it's no subject for reading the contract and making sure everything is consistent and checking that everything there is relevant and appropriate. Entire agreement clauses, another common clause that's often entered in, but it is actually covered by 12.4. But we see issues arising with this contract where there are things that are not perhaps included in the contract. So, for example, if there's been a letter of intent, which obviously as your lawyer we would always advise you to avoid at all costs if you can. And also procedures that are not mentioned in the contract that are actually being carried out by both parties, but it's missing from the contract for some reason, which was the case in Mears and Shoreline. Shoreline had engaged Mears to carry out repairs and maintenance on a portfolio of properties. Their tender price was significantly lower than the others. They were intending to enter into an NEC 3 term service contract, option C, quite importantly, but the work started 6 months before they entered into the contract. And it soon became apparent that Shoreline staff couldn't cope with the payment mechanism. There was a price list with hundreds of different items. Shoreline was struggling to identify the appropriate prices. So the solution, they came up with a coding system in order to make payment. When negotiating the contract, Shoreline assured Mears that there was no need to include the new payment procedure in the contract, and the contract was entered into with 12.4. Literally a couple of months later, Shoreline realised the code system wasn't achieving the savings they hoped for, and they had what they considered they had an overpayment of £300,000. So Mears conceded that 12.3 in the contract, which prevents amendment of the contract other than in writing, didn't apply. 12.4, the entire agreement clause, meant that there wasn't a side agreement or a way to vary it. So Mears brought a claim under estoppel for convention and representation from recovering the overpayment, and also said that they were acting in breach of the spirit of mutual trust and cooperation. And the court found there was clear agreement between the parties that the payment would be made using the code system, and it would be unjust, unconscionable, and almost dishonest for Shoreline to renege on these agreed terms. So again, this is an example that external procedures or agreements may be upheld by the courts even where there is an entire agreement clause. So it's a warning, again, that clarity under the contract might actually be preferable than just sort of winging it and hoping for the best. Looking now at just a few other clauses that have come up in which change the risk profile, which we sort of mentioned already. Changing the risk profile will always have adverse effects, which have to be followed through. So one of them, as we can see there, a common one, playing around with the disallowed cost definition. One that we've often, there may be reasons to do that. There may be particular costs, heads of costs, or things that you're thinking, well, actually, in those circumstances, that should be left out. One that's often seen, perhaps more of a lazy one, is all defects are disallowed, not just those after completion. Again, that can have quite an impact on the contractor. It can be a huge risk, and particularly if you were under an option C, then you're already sharing risk anyway. So it's sort of punishing the contractor twice there. I won't talk too much about early warnings because obviously John talked about that this morning. But again, if you're extending the list of early warning matters or playing around with it, just remember what's there. Isn't what's there already covering most of those circumstances that you're going to be looking at? We do sometimes see additional things that going there. It's almost trying to replicate the compensation events that are being added in. It's not necessary most of the time. Additional grounds for the project manager to withhold acceptance, another one that was quite popular, I think, in the survey. So obviously, as we know, there's various points where the project manager can withhold acceptance, which are up on the slide. Something we do sometimes see is actually adding to it another reason, which is for any other reason. The program can be they can withhold their acceptance for any other reason that occurs to them, which is obviously creating an unworkable position and could mean considerable delays to accepting the design or accepting the program. And if there's no accepted program, as we've said, we all know that's key. If there's no accepted program, what are the knock-on effects of compensation events? No one knows. The parties are unclear on what the delays under the contract are and what their liabilities are and what they're responsible for. So these generic or subjective amendments are definitely more of a curse than clarity. Now this one is a nice little favourite. That picture actually really does depict me when I actually read this clause. This is definitely a bad one. Hopefully you've all identified that now. So additional clause 60.2, it's in the wrong place anyway, because it's an additional compensation event. The following events are to be classed as compensation events. Compensation just capitalised for no real reason. Variations to the scope, including but not limited to adding or removing facilities or services. It's in the wrong place. It's really hinging on what 60.11 already does. Those are the days where I don't enjoy looking at Z clauses. So, but what else? I mean, we do see additional Z clauses going in. There can be a place for that, but as with all of this, it's about being clear and making sure that it's not covered elsewhere. What else do we see with compensation events? We see additional burdens on the compensation event procedure. We've seen things like revised programs to be issued with each compensation event. Again, how are you going to get an accepted program if you've got hundreds and hundreds or thousands and thousands of compensation events? How is that going to work in practice? It's just another burden. It's actually not. It's not really going to achieve the result that's perhaps intended. Deleting actions and time bars. The project manager and the contractor. That may be appropriate, it may not be, but think about the supply chain always whenever you're doing that. Think about that contract being flowed down. Will there be enough time for those parties to actually respond and enable, for example, the contractor to then respond? Deleting deemed acceptance by the project manager. That's again, I think, another one that was flagged in the survey. So obviously, if the project manager fails to respond to a notified compensation event or a quotation, or make its own assessment, the contractor can notify. If they get no response within 2 weeks, the contractor's quotation is deemed accepted. But without this deemed acceptance, there's a risk that compensation events just remain unresolved. Neither party are clear on their respective liabilities under the contract, and one of the really good mechanisms under the NEC is the benefits of that is entirely lost. Now, just quickly, I think I'm running slightly out of time. Just wanted to briefly mention burden of proof. I won't go too much into the detail of this one, but I think I have actually mentioned it to you in previous years, this case, which is about defects. But the real key to think about here is we've got this was option M under NEC 2. And this was in the case. And basically, the contractor was not liable for defects in the works due to his design so far as he proves that he used reasonable skill and care to ensure that it complied with the works information. So now, in that case, it was found that the contractor actually was liable, and then there was sort of a fitness for purpose obligation imposed in that, but liable for not having exercised reasonable skill and care or design. He had done that, but actually what he hadn't done there is exercise reasonable skill and care in the workmanship. So what NEC did a few years later in NEC 4 is actually changed the wording. In X15, so you'll know that as X15. So now that it says that the contractor is not liable for a defect which arose from its design unless it failed to carry out that design using the skill and care normally used by professionals designing works similar to the works. Now, the point of this is always think about the words that you're using. Think about how it's framed and the burden of proof. If that previous clause had been worded slightly differently, there could have perhaps been there would have been a bit different decision. It might not have been a different outcome. They may have still been negligent and responsible for the defects, but the burden of proof, it might have been that the client has to prove that the contractor hasn't exercised reasonable skill and care rather than the contractor having to prove it themselves. So just a few more examples up there. I know we're running out of time, so I'll just skim through them. Amendments to clause 17.1, I think we did touch on that this morning in terms of pushing all risk of ambiguities and inconsistencies to the contractor. Site condition risk has already been covered by Richard and Barry. Linking the subcontract to the main contract. Again, we've sort of covered this off, but again, it's that there are good ways of doing it, there are onerous ways of doing it, and there are clearer ways of doing it by perhaps including the specific clauses that need to be referred to, referring to specific extracts, for example, that kind of thing. And the last one there is adding subjective phrases such as best practice, which I might argue a bit with Glenn on and have my lawyer hat on and say they're not necessarily subjective, they may be tested in the courts. And particularly if you've got best practice or good industry practice, if you have a clear definition of that term, it may actually assist. And yes, you may be thinking, oh, well, it assists the client because it's basically saying that the standard of care is in accordance with industry standards and of a hydroelectric specialist contractor, which is quite a higher bar than just general contractor. But actually, if you haven't clarified that standard of care, you're not quite sure what an adjudication or the courts is actually going to say that is. So the clarity there can be of benefit for both parties. So just to wrap up, some Z clauses, yes, they will be necessary and inevitable. They are not all bad, but I have seen some very bad ones. NEC4 tried to address some common Z clauses, but we are still seeing some Z clauses that are commonplace. As I've said a few times already, read the contract. I obviously mean that. It's underlined and italics and with an exclamation mark. I'm obviously very excited about that one. The drafting really must be clear and consistent. Don't just copy and paste. Check that it's actually relevant and beware of changes to the risk allocation. They don't necessarily come with no cost. So thank you.